In this video, we'll talk about utility patent requirements. What do you need to obtain a utility patent on your invention in the United States? In a recent video, I compared utility patents to design patents and trademarks in terms of their requirements in a comparison chart. And I've taken this from that chart to focus strictly on the utility patent for today. So again, just to summarize the 6 issues that we've already talked about, are you required to have created the work or the invention? The answer is yes. Will a patent right be created automatically for you as soon as you invent it? The answer is no. Are you required to actually be using your invention? No. What are some other requirements? Subject matter, novelty, non-obviousness, enablement, and being the first inventor to file. This video will discuss these requirements in quite a bit of length today. Your application cost will probably be in the ballpark of about $4,000 to $6,000 if you work with me. And in the long term, you can expect to pay maintenance costs. So this video will really take a deeper dive into these issues, especially the ones that say yes, strictly for utility patents. There are 4 statutes that give us what we might call the classic statutory requirements for getting a patent. And their numbers are 101, 102, 103, and 112. Let's talk about those in plain English. Section 101 is patentable subject matter. In other words, what kinds of things can be patented? We've already discussed that you can't patent something like a novel, because that would be a work of art that would be more appropriate for a copyright. Patentable subject matter includes machines, processes, compounds, and articles of manufacture. A process can include software processes, although those are more difficult to patent for various technical and historical reasons than processes for manufacturing things. A compound might be something that you would put in a container, like glue or peanut butter or barbecue sauce or cosmetics. An article of manufacture is usually going to be something solid without many moving parts, like maybe a baby toy or a lab coat or a pair of goggles or something like that. The Section 102 requirement is also called novelty. And there are at least 2 parts to this. It's pretty complex. But one meaning of novelty is that you must be the inventor. This must be your invention. Again, you can't patent something just by introducing it into the U.S. Another aspect of novelty is that the invention must be relatively new, and that's defined by 1 year. I sometimes have clients who put a product on the market a few years ago, and they didn't bother filing a patent application because it was expensive. But now the product has really taken off and it's selling like hotcakes. And so now that there's money at stake, they suddenly get interested in filing a patent application for it. Well, by that point, it's too late. You have to decide pretty quickly, within a year after selling or even announcing or advertising your product, to get a patent on it if it would be eligible for a patent for other reasons. Section 103 is called, believe it or not, non-obviousness. Your invention can't be simply an obvious combination of previous inventions. This is a higher hurdle to pass than mere novelty. And I think that many first-time inventors are not aware of this requirement. So sometimes an inventor will get excited because she has made or conceived of a product that has not literally appeared on shelves before. But when you take a close look at it, it might be pretty much a combination of 2 previously existing products, like maybe just putting a handle on a flower pot or something like that. So that would be ineligible for for patenting because it would be considered an obvious combination of things that already existed. And Section 112 is called the enablement requirement. You must describe your invention well enough to enable someone to make it. You don't need a working prototype, but you also can't get a patent on an idea that is basically half-baked. You have to finish baking it. It's not enough to describe simply why you decided to invent it, or the problem that you're solving, or the purpose that the invention solves. You must go a step further and explain its form, how it addresses that problem. As long as you can describe it with words and images well enough for someone who is skilled to go ahead and make it, then you have properly enabled your invention. So we need to meet all of these requirements or else your application will get rejected. There's also a more modern requirement called the first inventor to file provision. This one creates a lot of confusion, so I want to clarify and correct some misunderstandings about this requirement. It's only been around since the America Invents Act of 2012. And the idea behind it is that if two inventors essentially come up with the same idea around the same time, and if they both file patent applications around the same time, it will be the inventor who filed first who gets approved. Not the inventor who thought of the idea first, but the inventor who filed his application first. And that is obviously to encourage people to file their applications. It also is consistent with practice in other patent offices around the world. Now, again, the first phrase here is first inventor to file. That key word inventor tends to get dropped when people throw this phrase around. And it kind of tends to become first to file in people's minds. That phrase is problematic and inaccurate. And I'll tell you why. What will happen is that an inventor will come into my office and he'll say, oh my God, I need to get a patent on this right away because I'm going to go out next week and I'm going to talk to some investors who want to invest in this project. I'm going to go and talk to some manufacturers and a 3D printer and a distributor, and I'm really worried that any of these people, they're all going to love my idea and they are all just going to rush to the patent office and file patent applications on it. And I don't want them to do that before me because, the first to file will get the patent. Okay, I hope you see the problem here. The law does not say that the first person to file, the first counterfeiter to file, will get the patent. No, it has to be an inventor. It has to be someone who actually invented and did not steal the idea. So the first inventor to file provision does not protect counterfeiters against you. It would only protect independent inventors, people who have never met you, never heard of you before. Just by some coincidence, came up with the same idea at the same time. Now, when you stop and think about it that way, you'll realize that it's not a common issue, and it's not something that you really need to spend a lot of time worrying about. I've never really seen it in my practice where somebody filed an application and then someone else who had never heard of him or her just independently filed the same thing at around the same time, even though that other person thought of the idea afterward. I've never seen it happen. So I want to assure you, relax please, because otherwise inventors get very nervous and antsy about this issue. As long as you are the first inventor to file your application, you'll be just fine. Let's get into the three phases of your patent's lifetime, basically. Phase one is filing the application. Basically, that means getting it from your head into the patent office. And the two major requirements of you at this phase are disclosure and fees. Disclosure means that you must fully describe your invention and the prior art to me, your attorney, and then of course you must pay fees. Let's talk about disclosure. Disclosure again means describing and bringing to my attention so that I can properly prepare your patent application. Now this has two really important parts to it. You need to disclose not only your own invention, but also what we call the prior art. And that means anything relevant that came before, especially immediately before, your invention. We want to find out sort of what was your starting point and how did you improve upon it. This is super important for me to get across to you because you're probably going to be in a field of industry that I'm not super familiar with. So there are going to be a lot of things that you know about your field of technology that I simply don't know. And somebody can come into my office and describe his invention for 20 or 30 minutes, and I still might not have any idea what is inventive about it because I don't really know what to compare it to. So they're both really important, your invention and the prior art. So how do you disclose your invention to me? I will be presenting it to the patent office, so we really only need you to describe this to me. So eventually it's going to become words and images, and you can provide those words and images if you're comfortable with it. Some clients are better at that than others. But those are not the only options. If you have a prototype, you can bring it in and show it to me. You can demonstrate how it works. I've had some pretty fun demonstrations in my office before. You can take a video, or if you demonstrate it in my office, I might record a video as well that I can refer to later. Or photographs, obviously, hand drawings. You can refer me to websites. Pretty much anything that it takes to convey what your product is. Then you also need, like I said, to disclose to me the prior art. And the way I like to describe this to you is to sort of talk me through your moment of, your aha moment, the genesis moment. The way it usually works with my clients is that they are working with something that already existed, and they find that there's something frustrating or incomplete about it, and then they sort of have an aha moment and they say, oh, well, what if I borrow part A from this gadget over here and put it on this one? And it's usually a very specific application. So I would like you to disclose to me not only the product that you are using that gave you this idea, but also the product that you're borrowing from. Let me make a more specific example. Let's suppose that you're getting your hair styled, and your stylist is brushing your hair with one hand, and she's spraying your hair with water with the other hand. And you decide that that's very awkward, and it would be so much more convenient if she just had a brush that had a water squirter in it. Like squeeze the handle of the brush and water comes out. So if I asked you to disclose your invention, what would probably be foremost on your mind would be the field of brushes. So I would say, what is the prior art here? And you might be tempted to show me a lot of different brushes and just say, see, none of them have squirt bottles in them, so my invention is absolutely brand new. Those are products that would serve a similar function. But I also need you to disclose to me inventions that have similar form, especially the key features, which in your case might be a squeeze handle or a trigger that you've put on the brush. I want to know where you got that from. So you need to be disclosing to me not only the field of brushes, but also the field of squirt bottles or anything that kind of dispenses water in a spray. So it's important for you to disclose both of those parts of the invention to me. It's easy to just point to a whole bunch of brushes and say, see, none of them squirt water. But when you disclose the brush and the squirt bottle, it's much more likely to be seen as an obvious combination of those two. And that's basically a move that patent examiners have that a lot of inventors aren't anticipating. So it's really important to me that you disclose all the parts of the invention so that we can really analyze the obviousness element honestly before you spend thousands of dollars on your application. All right, so as the inventor, of course, your second obligation will be to pay fees. You're essentially paying three different parties: me, your lawyer, and an illustrator, and the USPTO. If you decide to work with a different lawyer, that lawyer may or may not have an illustrator that they collaborate with regularly. So you might have to pay 2 or 3 separate payments because of all that. If you work with me, you can expect your ballpark figure total cost to be in the range of about $4,000 to $6,000. There are large firms that would cost twice as much, and there are cheap firms that cost about half as much. Each of those has their obvious disadvantages. So if you're looking for a good middle-of-the-road solution, I think I would be a good match for you. Phase 2 in your patent's lifetime is prosecution and approval. And this phase involves a lot of waiting. It's called the patent pending period. You've probably seen that phrase before. As soon as you file your patent application, your patent is pending, and you are allowed to use that phrase, patent pending, on your packaging or your website or whatnot. So there's going to be about a 1 to 2 year wait while the patent examiner works through his or her backlog. In that period of time, by the way, your patent application will be published. That doesn't mean that it's approved. It doesn't even necessarily mean that the patent office has looked at it, really. It just means that the application that we filed is now published so that anybody in the world can look it up. It'll be available on the USPTO website, and you might be able to access it through something like Google Patents as well. All right, now let's suppose that we've gone through this 1 to 2 year wait, at which time a patent examiner will read your application and issue what's called an office action. And that will basically indicate here are the things that the examiner is ready to approve, and here are the things that need work or that need to be changed or removed or added before the application can be accepted. Or sometimes the examiner just says, no, I just can't accept this at all. I just flat out reject it. Usually it's an issue of things that we will have a chance to redeem ourselves. And the process of sort of arguing back and forth with the patent examiner until approval is granted is called prosecution. So that'll involve some legal fees. Typically, you might expect to pay about $1,000 to $3,000 to an attorney such as me in order to get your patent prosecuted and sort of over the hump. Okay, so let's suppose that we do that. We prosecute successfully, and that process will go on for months, 6 or 9 months pretty much from beginning to end. And at that point in time, if the patent does finally get approved, your final step is just to pay an issuance fee to the USPTO, which is small in comparison to everything else. Most of my clients qualify as what's called a micro entity. If you're an individual inventor or a very small corporation, then you're probably going to be a micro entity. The income cutoff is pretty generous. It's over $200,000 a year. So if you qualify as a micro entity, your issuance fee will only be $300. So once we've successfully prosecuted it and you pay your $300 issuance fee, congratulations, you are going to get a patent number with a registration date. And that takes us into phase 3, which is the long term, after your patent has been granted. So in the long term, you can expect to pay what's called maintenance fees over the first decade. You don't have to pay the maintenance fees if you've decided that you're not interested in pursuing the invention anymore. But if you don't pay those fees, then your patent will lapse. It'll expire, which will basically allow competitors to come in and make your product without having a license from you. $3,000 would be what a micro entity would pay. A small entity would pay twice that much, and a large entity would pay 4 times that much. And as long as you pay all your maintenance fees, your patent will have a total duration of approximately 2 decades. At that point, it will expire forever, and you'll obviously still be free to make and sell and profit from your invention, but so will anybody else who wants to. It passes into public domain after that 2-decade period of time. So to summarize, I'd like to bring back that chart we started with. This is modified slightly in light of the things we just discussed. So filing requirements to get a utility patent include patentable subject matter, novelty, non-obviousness, proper enablement, and being the first inventor to file your application. The application process and costs involve disclosing your invention and your prior art to me, your attorney, and paying about $4,000 to $6,000 altogether to me, an illustrator, and the USPTO. The prosecution phase comes 1 or 2 years later. It will involve probably about $1,000 to $3,000 in legal fees, and that's required to get past the patent examiner to refine the application to a point where the examiner is ready to accept it. In the long term, you'll have to pay maintenance fees, which start at $3,000, and they're charged on basically a sliding income scale. So if you're a high income individual, you'd pay twice this much, and large corporations would pay 4 times that much. Once again, thank you so much for watching. I hope that you have found this helpful. I hope it's what you're looking for. If you'd like to discuss your invention or your patent application with me further, my website is fagerlandlaw.com. My name is Scott Fagerland. And on my website, you'll find an appointment calendar where you can schedule a free 30-minute consultation. So let's get this ball rolling. I'll talk to you then.